Today is a day that would be remembered in history of India. GST, a revolutionary change starts today. It was bought to ease out compliance headache for the general public and bring down prices in the long run. RERA was introduced a few months ago with similar intentions. अरे कोणी घर देता का घर जिथून कोणी उठव नव्हे अशी जागा ढूंढत आहे कोणी घर देता का घर. These legendary lines symbolize the pinch a common man faces to buy his own house. It is the aim of every working man and the dream of every family to have their house of their own.
अरे सुयोग, तुला एक सांगू का? माझी आजी म्हणते की लग्न अशा मुलाशी कर ज्याचं स्वतःचं घर असेल. पण माझं स्वप्न असं आहे की लग्न करण्याच्या आधी माझं स्वतःचं एक घर असावं. सर्वात आधी स्वतःचं घर आणि त्यानंतर जोडीदार. हो की नाही रे मुलींनो? रोटी, कपड़ा और मकान. It features in the three basic necessities reiterated over the years in Bollywood. There is something permanent and something extremely profound in owning your own home. You ask a person from my generation, and our biggest worry is to buy a house in Thane, let alone Mumbai. Even if we assume that as successful chartered accountants, we have enough money to buy our dream home, there are still so many nitty-gritties of buying a house.
A lot of efforts have been put down by Thane branch of ICAI to assemble this expert panel for you all today. RERA affects the builder community the most, and we have on stage a builder with us, an advocate who has represented builders and their associations. We have the chairman of Consumer Forum representing the voices of all us consumers. And finally, someone from our own CA fraternity to raise our perspective. And to manage this all, we have an able moderator to guide us through these proceedings. It would be now my privilege to hand over the reins of this panel to the moderator, CA Ashwinji Shah. Sir, the panel is all yours. Thank you.
Thank you.
Good morning, everybody. On the eve of 68th CA Foundation Day, I congratulate each and every chartered accountant to be active role model in the national building. Sir, we are very less in number, hardly 0.03% of the total population. But when it comes to the financial and economic regulation and compliances, we are the front runner in the Indian economy. There are many alumni who have reached a new heights like Piyush Goyal, Suresh Prabhu, Deepak Parekh, and so on. The list goes on. We are the person who bridge the gap between authority, government, and the taxpayer and various industries. Now, real estate has been talked a lot since last 60 days. There are many headlines, there are many speeches, seminar, etc. But when we come to the reading between the lines, we need to have this panel discussion to read between the lines. Now, preamble of the RERA focus on only two things. The two only things, that is, one is regulation and second is development. These are the most important part of the RERA. But currently, the law, all Indian laws are focusing on regulating the real estate builders and developers rather than their development. Now, take an example of a school-going boy. He makes some mistakes and we punish him. But if goes on repeating his mistake, then we as a parent, we try to see his surrounding issues. We try to solve that issues. And we come to some solution and we allow him some development. So that child develop, he acquires some degree, he start earning. Now again he is put to regulation because of our marriage system. So he is again put to that regulation. So we all married people know how this regulator works, right?
There is no bigger regulation.
Yeah. Now we cannot neglect the importance of this real estate sector because the real estate sector is the second largest employer in Indian economy after agriculture. So even today in sluggish condition, they are the second largest employer. Take an example of a small project of even a 7-storied building. It will employ at least 250 persons. It will be the source of livelihood for 250 persons. So we cannot ignore that. Again, by 2020, India will become the youngest country in the world in terms of aging of population. And with the concept of nuclear family system, we will be having a huge demand for housing. Yes, there would be change in the trend for affordable housing and the ticket size. that is going to make a difference. Certainly that is going to make a difference. But when I talk to the builder, they say now with this RERA we are finished and all these things. No. On the contrary, RERA is giving you a chance to come out as a good builder. Of course, there are some players in the industry, in each of the industry, that is the good, the bad, the ugly. So now RERA will give chance to identify the customer, who is the good, who is the bad and who is the ugly. Certainly this is a chance to the promoter to come out as a good builder. Now RERA, immovable property is in a concurrent lease. So central as well as state has the concurrent jurisdiction. So central government has enacted a law called RERA Act 2016 and states are given power to notify the rules. They are given power to constitute the authority for the implementation. Again, they are given power to establish tribunal for the quick dispute resolution. So this is how the RERA will work. And of course, from the very day one, 1st May, the online window of MAHARASTRA is open for all for registration and all the credit goes to the authority. They certainly deserve a round of applause. Please carry on. As of now in Maharashtra, as the figures come out, only 200 projects are in pipeline or registered. But as per the estimate which are going on, there are nearly 75,000 projects in Maharashtra ongoing. Because now entire Maharashtra is covered under planning area. So each and every development in planning area will be governed by RERA. So there are 75,000 projects to be registered. Now when we talk of when people talk of RERA, everybody says it is favoring consumer and it is anti-builder. So now my first question will be to Ajay Asar. Now you are suddenly put on a financial diet. You cannot consume what you want to consume. You are put some restriction also. You cannot do this activity, that activity. You have to be within a financial discipline. Now, there is no such provision for any other industry, like all these financial restrictions. So how you feel? You feel you are discriminated or ill-treated?
First of all, I would just take this opportunity to congratulate the MAHARASTRA authorities here. The way they have moved and the way it is functioning already, especially the interactiveness that they have shown, like whatever queries are put up and they reply to it and giving a human touch to it, understanding and giving clarifications is helping us also and is helping the consumers also, which is really very highly appreciable because that is how everybody right now is in a quandary. There are so many questions, and if these questions are replied, life becomes easy, especially things like carpet area plans that was given. It has given such a relief to us that at least there is something on which we can benchmark, so we don't go wrong anywhere. So that's I would just like to say that. Regarding the financial plan and financial diet, see, every industry is in a growing phase, especially if you see our construction industry. First of all, we were wanting a status of industry from a long time. We have never had a status of industry. Now, if a status of industry is given, finance becomes available to us easily. Correct. Once we get easily the finance is available to us, then all the moderation, all the control, all the planning can be easily achieved. For example, infrastructure projects. Infrastructure has been given financial status, industry status from day one. Every project that starts, it is almost mandatory to do a financial closure of that project. But till now, we have not been experiencing this system of doing a financial closure. What we used to do is, जब तक खड्डे खोदे नहीं है तभी तक booking आ जाता था. तो booking आ जाता था तो then the cash flow was there and we used to do work in a भाई पैसा आ गया तो we don't need to go to the banks. And suddenly somebody becomes greedy and increases the rate, and then the booking stops. Then with extra money that he has, he used to go and buy other lands. So this project suffers. Basically, this has been the story of a lot of developers. My request to authority again is, you have given industry status to affordable housing, but you should press that with this regulation, every project that is coming should be given industry status. Why not? Now we are regulated. Give us good financial opportunities and regulate it. There is no issue on that. Once that is regulated, we get the finance availability at a cheaper interest rate. Everybody is going to fall in line. Biggest thing is we don't get funding for land, which again is a very big issue.
Yeah,
once all that falls in line, then it is, see, when you are regulating us, please put us on an equal footing with all other industries. Let there be no discrimination there at least. That is what our humble request is.
So what Ajay wanted to say is, capital is one of the most important factor for any business, whether it is a manufacturing sector or service sector or a real estate industry. So capital, of course, they will bring their equity, but then there has to be some loan also, debt also. Now if that debt is easily available at an affordable rate, like what is happening today is, there were some unorganized investor. They used to charge 2.5% per month, and then the cost goes up and then the project become unfeasible. And because of delays in approval system and all these things. So what he want to say is, provide us the finance at a cheaper rate and we are ready to serve the...
Still for land we have to go to NBFC.
Yeah.
NBFC is charging 4% more than the normal rates.
Correct.
No NBFC will give less than 20%, 18%, which is not viable now.
So this would be our suggestion to the authority to make further suggestion to Reserve Bank and all these things. Say, let bank also give finance for land, because land is the basic raw material for any project. It is not speculative item, it's a basic raw material. Now, one question I would ask to Kapadnis sir. Sir, on 11th May, RERA has come out with an order which defines landowner as a co-promoter, even investor also, as a co-promoter. Now, there has been apprehension in the legal fraternity also, in the mind of public also, okay, when the definition of co-promoter is not there in the act or rule, how RERA authority can bring that definition? First of all, whether RERA authority is allowed to make the law or frame the law, because to what we understand is RERA authority is the administrator of the law. You can certainly make some suggestion to the state government, central government, but whether by doing this, because this is altogether a new definition has been brought, because there are many contracts which are signed by the landowner prior to this. So it has affected a lot to most of the landowners. They are not going to cooperate also. This is the current scenario, what I have been talking to many builders. So whether this order itself, what is your view?
The definition of the promoter is very clear. It says that one who develops or causes to be developed, or who constructs or causes to construct. So all those persons who are going to take share in the form of cash or in the form of certain built up area, then he comes within the definition of promoter. And we have issued the notification just for the purpose of clarification, because all these things are there covered under the concept, that is the definition of promoter, and therefore we have not gone beyond the provisions of the law.
Now that definition of promoter says a person who construct or cause to construct. Certainly landowner is a person who cause to construct. Again, Supreme Court has invariably said that consumer and the contract between builder and consumer, builder act as a works contractor for the consumer once he books. So now whether that consumer is also a person who cause to construct? Because again, this confusion will also remain, because now builder is a works contractor as per Supreme Court judgment. So whether consumer himself is a person who caused to construct? Again, that clarity is needed, because consumer is a allotee.
To my knowledge, that particular litigation was pending between the developer and the person who gave his land to develop. That was the litigation in respect of the terms and conditions vis-a-vis the status of the two. And in that context, those observations have come. So we have to read the judgment carefully. But I think that when the law is clear, the recent law is there, RERA, and it has defined where all these persons have been covered. Therefore, in my opinion, there is no ambiguity.
Okay. Now coming to Shailesh, as a consumer, president of Consumer Association, do you feel that whatever RERA has brought is sufficient or you expected something more?
रेरा एक प्रयत्न है, आगे भी बहुत सालों से कोशिश ऐसी रही है कि कंज्यूमर्स और फ्लैट बायर को न्याय मिलते रहे, उनको सलामत और अच्छा घर मिले, कुछ कानून बने, कंज्यूमर कोर्ट, मोफा, लेकिन उसमें कुछ त्रुटियां थी, कुछ डेफिशिएंसीज थी। तो सरकार ने एक कोशिश की है, रियल एस्टेट रेगुलेटरी अथॉरिटी, आपको मालूम होएगा, आप स्कूल टाइम से या तो घर में भी देखते होएंगे, मॉनिटर की क्यों आवश्यकता रहती है। कैप्टन इज समथिंग डिफरेंट, कैप्टन वो लीड्स, बट यहाँ तो मॉनिटर इज फ्रॉम एन अमोंगस्ट। तो कोई भी ये रेगुलरिटी जो कार्य रेगुलरिटी का जो फंक्शन रहेगा कि जो एक्टिविटी चल रही है, ऐसा नहीं बता रहा हूँ कि बिल्डर की तरफ से त्रुटियाँ हो, डेफिशिएंसी हो, बिल्डर लैप्स होता है, कंज्यूमर्स फ्लैट बायर का भी लैप्स होते हैं। तो रेरा का कार्य मेरे हिसाब से मॉनिटरिंग रोल रहेगा। दे विल रेगुलराइज द सिस्टम, रेगुलराइज द एक्टिविटीज ऑफ द बिल्डिंग कंस्ट्रक्शन, रियल एस्टेट डेवलपमेंट। ये किस तरह से लोगों को अच्छा घर मिले, बिल्डर भी अपना अच्छा तरीके से बिजनेस कर सके, ये रेरा की अथॉरिटी क्षेत्र में आता है। एज अ मॉनिटर दे विल हैव टू वर्क। थैंक यू।
Thank you, Shailesh ji. Now coming to Arshad, now there are many confusion prevailing as regards in a layout type of condition, you have some FSI to be consumed at future date. Now the law says that the FSI available to you as on the current, as per current DC regulation, you should disclose that FSI. But suppose now 2034 some DC regulation is coming and builders are expecting more FSI. So whether builder will be allowed to disclose FSI as per current DC regulation, or he can predict some FSI coming in future, and whether he will be entitled to that FSI, because most of the litigation are pending with the MOFA on this line only. The benefit of increased FSI should go to association or to the builder.
See, first point is the rules as well as the Act contemplates that whatever is existing FSI.
Okay.
So if you go on the site for registration of the project also, there are two facets which are mentioned. One is sanctioned FSI and one is proposed FSI. Now that proposed FSI which is mentioned is what is expected as per present DCR.
Okay.
You can't contemplate something which is likely to come in future and say that yes, I am going to consume that FSI and therefore now register my project with 4 or 5 FSI. Okay. So what is expected under RERA is one, what is sanctioned FSI, and two, what is the maximum FSI which you can consume as per prevailing DCR.
So in that scenario, in future, because
of course the authority is sitting here, so before I make such comments, they would be also confirming that. But you can't take, like you said, that 2034 we are contemplating 0.33 FSI more. So today I will expect that and load that and show that my building is going to be 36 floors instead of existing 33 floors. That is what my understanding of RERA would be.
So in that scenario, because project sometimes goes for 6 years, 10 years. So in that scenario, whatever is the increased FSI at later date, certainly association would be entitled, or their consent would be required to consume
consent.
That FSI.
You are right. Consent would be required to consume that FSI or to load that FSI as in by way of additional building or additional floors, because ultimately whatever additional FSI if you want to consume, you will have to make change in the either layout or in the structural design of that building, which would require the consent of the...
In that case, suppose I have a land of say 30-40 acres, and current all that land is not subdivided, it is a single land. I don't want to subdivide also because I want to take some benefit of colonies and all these things. So initially I go for only 5-6 buildings. So in that scenario, I am not transferring the land rights of entire 40 acres. What I am doing is transferring the land rights of these 2 buildings only. So in that scenario, promoter will always say, this increased FSI should belong to me.
No, Anil bhai, there are 2 things. As far as transfer of a completed project is concerned, RERA contemplates transfer of the structure, not of the land when it is a layout.
Okay.
Right? So when you have a registered phase, that FSI only regarding, let us say you can construct 40 buildings, but if you have disclosed only 2 buildings and registered only 2 buildings, then in that case what you are contemplating is right, that the builder can go on consuming the additional FSI whenever it is available in respect of balance land. But take a case where the entire layout is already consumed by the promoter and then FSI is developed. In that case, he will require the consent. Without consent of the existing allottees, he cannot go on consuming. Otherwise, see, the idea of introduction of RERA is to stop builder somewhere.
Yeah.
Because otherwise he starts project from 1 FSI, he goes on for 10 years, consumes 3 FSI, says 0.25 is still coming.
Correct,
So that last floor, he never gets the OC.
So there are
So
delay.
26th floor he'll come, he will get OC up to 25th floor, 26th floor OC he will never take. So he'll say my FSI is coming.
So he will try to delay the conveyance, and that's what has
That is why
happened
the RERA has come,
in Maharashtra.
that you somewhere finish the project.
Yeah, because in Maharashtra there are so many society where conveyance has not happened.
Exactly.
Now we have with us Ramesh Prabhu also on this point. Now what are the figures of this society which are going for deemed conveyance, and what will happen to all these things?
In Maharashtra, we have about 90,000 cooperative housing societies right now registered. Maybe more than 2 to 3 lakhs apartments and other buildings which are not even registered and got the conveyance. Now, as far as 90,000 cooperative societies are concerned, 70,000, approximately about 70 to 75% of the cooperative housing societies still have not received the conveyance. Now, that is the reason in the year 2008, the MOFA was amended wherein the deemed conveyance concepts are introduced. Still now, even the deemed conveyance is happening. But unfortunately, number of societies are still not applying for one or the other reason. One of the reasons is that the latest GR of 2016 says unless until the society gets the occupation certificate, they cannot go for deemed conveyance application. That is one issue which is pending. Secondly, of course, there are stamp duties and other issues. Now let me come to the section 17 of RERA. Now if you look at section 17 of RERA, which of course I would request our judicial member of the RERA, Kapatni Sahab, to confirm or otherwise about section 17. Section 17 contemplates 3 types of conveyance. And all these 3 types of conveyance deed, the draft conveyance deed has to be uploaded at the time of registration of the every project. Unfortunately, I have seen few of the projects out of 70 projects which are registered, which I could see in the website, hardly 2 or 3 developers have given the draft conveyance deed of only 1. The rest of the 2 other draft conveyance deed have not been given. Now what are the 3 conveyance deed which is contemplated? The one is the conveyance of the apartment. Under section 17 it says, every promoter shall convey the apartment to the allottees. Now, there is an agreement for sale, and accordingly there has to be conveyance of the apartment. That is a flat. Unfortunately, nobody does it in Mumbai. It has to be done. That is the section 17. The RERA overrides all other act. Even the MOFA has been overridden by wherever inconsistency is there about that. Secondly, the association of allottee, where we are talking about a cooperative housing society, will get an undivided right of land title. Now, I don't agree with the Maharashtra rules, because Maharashtra rule is a subsidiary legislation. It cannot override the parent act. The Parent Act, Section 17 is very clear. It says undivided right of the land, which is concerning that project which you are registering, has to be conveyed within 3 months from the date of occupation certificate, which means the conveyance of the undivided right. If you have got a layout of 40 acres, no problem. You are developing one building which has got an undivided right of 2%. Convey 2% of undivided right to there. You cannot convey the structure. The structure is conveyed to the apartment owner, that's the allottee. If the RERA rules is going to say, the law will be tested in due course. There are so many intelligent people who will definitely test the law in the course. Third, which is contemplated as a conveyance, is suppose I am giving certain area to the what is known as competent authority. Who can be a competent authority? Of course, municipal corporation, CIDCO or MADA, who is facilitating that redevelopment or the development, where we are required to give certain area, maybe 20%, 10% as an amenity area to the competent authorities. The conveyance of that also need to be given. So these are the three different conveyance deed which need to be. Section 4, subsection 2 and clause G is very clear. You have to give the draft agreement for sale. You have to give the draft what is known as allotment letter. Also, you have to give the draft conveyance deed. When I'm talking about the number of developers who have registered the project, what they are saying is there is no button which shows that or the window which facilitates for uploading what is known as draft conveyance deed. I don't agree with that. When you can upload agreement for sale, you can upload allotment letter, there's the same window where you can add 3 more conveyance deed. If there is no area to be given to competent authority, that leave it, but it has to give. I also have gone through the MAHARA, the project which has been registered. In fact, they have not even uploaded agreement for sale. If MAHARA authority does not upload agreement for sale, which is contemplated in the act, I'm very sorry. Even the government authorities are taking the regulator for a ride. And maybe the regulator need to look into it. Only allotment letter has been uploaded. Not even agreement for sale has been uploaded. So, secondly, you have to require to give 5 years back record of the MAHARA, whichever developments have been done. Nothing of last 5 years, maybe around 100, 200 projects in Maharashtra, MAHARA must have developed. Not a single project detail has been uploaded. That means you are taking law for a ride, as far as even the government departments are concerned. So I'm very sorry how the regulator will be taking view of that. So if you have to say that when the law demands agreements for sale has to be uploaded, allotment letter has to be uploaded, draft conveyance deed has to be uploaded, it has to be uploaded. That is what I would say. Kapadnitsa would be, I would be very happy if he can.
That is very sure. Okay, now even public bodies are also covered in the definition of promoter. So they are in par with the private player. So that is a one very good sign which RERA has given. Now coming to CA Paras Savla, there are deviation so far as, sure.
I fully agree with the view taken by Mr. Prabhu. We have to see that agreement to sell is simply an agreement. It doesn't pass any title. Title passes only when the conveyance deed is executed. In other words, the sale deed is executed. The sale deed of the apartment will have to be executed in favor of the allottee. So far as the common area is concerned, its conveyance deed, that is the sale deed, will have to be executed in favor of the association of the allottees. And it is true that the draft of the agreement as well as the drafts of the conveyance deeds to be executed in favor of the allottees or in favor of the association will have to be furnished so that the purchaser should be able to satisfy himself as to how I am going to acquire the title. Unless and until the title, that is the ownership, passes to the allottee, he would not be able to transfer it or his legal heirs would not be entitled to inherit. So far as the provisions of MOFA are concerned, in those days it was thought fit that the ownership would pass to the society or the association and the purchaser would be treated as member. Therefore, only the letter of allotment was serving the purpose. But now, after coming into force of the new act, it is necessary that the sale deed will have to be executed. Many people are asking me that once the agreement of sale is executed and it is registered, it is not necessary to execute the conveyance deed. Final conveyance deed is necessary. You have to see that when you are registering the agreement of sale, you are paying the stamp duty. So when you are executing the conveyance deed, it is not necessary again to pay the stamp duty. Therefore, it is my request that the promoters should see to it that the conveyance deeds in favor of the society or the association as well as the allottees should be executed. The mere agreement is not sufficient.
Sir, question to you. What will be the position on about the leasehold plot? How the conveyance will be conveyed and what will be their rights?
So far as the superstructure is concerned, superstructure is to be conveyed. Land is, of course, it is held on lease. So ownership title, that is not given. Only the right to occupy and to use it is given for a certain period. That is called lease. Yeah, Harshad.
Sir, as you expressed that conveyance deed and everything needs to be done, I totally agree with you. There's no quarrel about it. But the question is, when you go for registration, Ketan is here from KPMG, there is a place for uploading document called agreement for sale and allotment letter. There is no place for uploading conveyance deed of the society or for that matter, the conveyance deed of the apartment, nor is it asked for in the form. So it is very difficult for a person who is registering. First of all, it is a internet-based software where we can upload only what is required. We can't even put comma or alphabets or give our own comments. So I do agree with you that conveyance is required for the purposes of transfer of flat or the building. But there is no place for provided there.
So shortly, I cannot commit a time, but shortly we'll come out with one option wherein you can submit anything other than what has been asked.
In any other item.
Anything other than what has been asked, you'll be able to submit it there.
See,
I would say those who have submitted, they are already submitted. If you look at Mayfair, they have added along with the allotment letter, agreement for sale and the conveyance deed. It has been put in one.
You can always. So now, even in allotment letters and the agreement, there is an option to add. There's an add button. You can always go and add. We are not stopping you from adding it.
See, only thing in that it is not written. They have written only allotment letter and agreement for sale. One more word, conveyance is not added. Therefore, people are not adding. I would say the section 4, subsection 2, clause G is very clear. You have to upload all the documents and you are giving an affidavit B wherein it says that all the documents as required under the act and rules and the regulations are being submitted. Yeah, yeah. And if you are not submitting, that means you are giving incomplete information wherein a registered promoter may be liable for penal action if somebody complains. So the consultant or the promoter should be in a systematic way, see that wherever it is not possible, at least add in form B, which is called a declaration. In the declaration, it's a PDF form. It can be go on adding whatever is needed to be added. I am of that view.
See, why all these things are disclosed on the website of the RERA by the promoter? Because now consumer, before taking any decision while booking a flat or apartment, he will go through all this detail. He will make sure that the things are transparent. Because many times what happens when we go to booking site of any builder, the sales department always tell us कि boss 80% 90% हमारा book हो गया है, अभी कुछ 10% orthodox flat बचे हैं. But now customer will go and tell the builder कि boss खाली 20% ही बचा है, आप मुझे 80% दिखाइए. So this is going to make the difference with the website because there will be quarterly update after registration. How many number of apartment you have booked, what are pending, what are the approvals pending. So all this detail will be helpful to the customer to take the decision. So now he is an informed customer rather than an ignorant person. Yes, Ketan.
So rather than adding in the form B, as of now, you can add it in the agreement and layout. Also. That is better that because is better. Form B is something that you are declaring.
Correct.
So don't add it there. Yeah. And there is no add button in form B. So you cannot add subsequent documents. What you need to do is either go in the layout, in the agreement, or then when we come up with the option to add other, you can always go there and add it.
Ketan, as regards this form B, now even landowner are also required to sign and execute, upload this Form B. But right now they are not cooperating, they are not understanding why we should be put under RERA, because our agreements are executed prior to 1st May. So they may not cooperate with the builder. So in that scenario, what to do? Because we have to click, if there is co-promoter, we have to click yes, and there are some details, and then again Form B will be required as per 11th May order. So in that scenario, what one should do?
Convince.
No, convince, but then
See, right now, the legal way to do is convince.
or can builder give one declaration that we have tried our level best and he is not cooperating, because then RERA will give direction to that landowner to do this, because why builder should be penalized for his non-cooperation? Why he should not upload his registration before 31st July?
So see, these are certain gray areas which needs to be highlighted to the authority. Okay, and these points have already.
So what I want to say is, suppose nobody is, that landowner is not cooperating. So can I give declaration as well as one letter to the authority saying that I have uploaded this detail without the Form B of landowner, he is not cooperating, these are his detail, please give him some direction.
अश्विन शाह जी, आप जब डेवलपमेंट का अधिकार लेते हो, आप पावर ऑफ अटर्नी भी लेते हो. हर जगह में आप लैंड ओनर का पावर ऑफ अटर्नी वापरते हो. फॉर्म बी आप नहीं वापर सकते पावर ऑफ अटर्नी.
I think Arshad want to say something.
Sir,
I think
I
you
will
can
tell
use
you,
the power of attorney and use it.
I have a case, a similar thing, where we have gone into a joint development agreement. This was done 3-4 years back. We have gone ahead with the project. My landowner is a 75-year-old man suffering from cancer, and he only has a wife to support him, the two of them, nobody else. Now he says, "Mujhe ye janjat mein nahi jana hai." उसने माल लिया है मुझे से, and almost 70-80% is sold off. A lot of monies he has already received. तो अभी मुझे नहीं जाना है. What should I do? I'm stuck. Kind of, without, I mean, the document was done 3 years back, not today.
Yeah, I think Kapatni sir, if you can throw some light. But according to me, one can use the power of attorney which is given and go ahead with it.
I don't think power of attorney one can use for affidavit, because it says that the title of the land is free and all these things.
You would be happy if power of attorney is allowed to be used.
I don't think legally whether it is allowed, Arshad.
Yes, sir.
Okay. Sir.
I am going to adjudicate the disputes. Therefore, there are certain reservations. So I will not comment upon the individual cases. But the position of law is very clear that even the landowner who wants to take share in the profits, maybe in kind or in money, he is the promoter. So it is in between the promoter and co-promoter to sort out their disputes.
But then timeline of 31st July will go away if they want to sort it out. It may prolong for 2-3 months. Then in that scenario, because promoter is ready to register.
Then in that scenario, come to us.
Yeah.
We'll adjudicate the dispute if the law permits.
Yes, sir. With that declaration.
And I think
Because the authority has the power to give certain directions.
Yes, that's what can be done. Yeah, certainly.
Ashwin, there is one point that Ajay bhai, when you have the landowner sharing area, that landowner also needs to have a bank account. And unless you fill in those details, you won't go further in the software.
Okay.
Yeah.
Because for opening bank account,
Again, the
instant has
signature,
to go,
yes.
right? Now coming to Paras, now Act for withdrawal purpose, Act says what should be withdrawn is the cost of percentage completion, whereas rules says cost incurred, that is cost incurred divided by estimated cost into estimated cost. So ultimately rule says cost incurred. So there is a deviation between Act and rules, and as Arshad said, rules are subsidiary legislation and Act is a parent law. So whether this Form 3 given by the regulation needs to be revisited, redesigned?
Just a couple of points on that. The Act gives me what is the cost to be incurred, and it doesn't allow me to withdraw the money. The objective of the Act is that I should allow the money what you have already spent, you can withdraw that money. Because they are regularly saying, the government also keeps on saying that this is just to regulate you, nothing. But if you incur something, we are there, you can withdraw that money. looking at that objective, I think so, the form which has been given, that allows you to withdraw not a percentage of the amount of the, of the whole expenditure, but 100% of the expenditure what you incurred on the land. If you are going with that logic, I don't think so form 3 overrides what the act is given.
No, Act clearly says the withdrawal should be in proportion to the cost of percentage completion. Now, what is that cost of percentage completion?
No, I agree on
Suppose
that. I agree on that.
I
That's
give you one
the gray
example.
area. That's a gray area where the what is the cost of percentage completion. But in that scenario, when Act can't put me embargo on the point where I already incurred something. For construction, because land cannot be come in the percentage completion. Land is already there. Percentage completion come only on superstructure.
Because land cost, inclusion of land cost will amount to earlier withdrawal rather than proportionate withdrawal.
But other logic, what I can say why the form is that because land is a cost, as Mr. Asar said, that you don't get the funding on the land.
No, that is the current practices. In future, you may
Future,
be
but
getting.
currently what is there? I already incur something on land, so I don't foresee there is an issue on that. So you are allowed to withdraw on the, but that's what in line
What
with
will
it.
happen if we allow the promoter to withdraw the land cost also, and suppose at future date he fails to carry on the project, and there are provision of revocation also. Authority can revoke the project, hand it over to somebody else. Now, while handing over to somebody else, that feasibility also needs to be examined, because if he has already withdrawn the land cost, then that feasibility will be missing, and the authority will not be in a position to hand over to somebody else in a profitable manner, because any other person coming would also require some profit earning. He can't incur the losses and complete the project.
Certainly,
so
that's
that is one of the risky area. Again, there are deviation on
There
this
is a gray area, I appreciate on that point, but we need to go with the intention of law, one thing, and we see that the builder is not struck at any point of time. He need to carry on the project, otherwise he will never able to fulfill the commitments what he has given to the consumers.
Sir, one small thing. Now there are old arrangements have been done of escrow account. Now they needs to be redesigned. Separate account has to be made. Now how you ensure timely recovery of principal plus the interest?
See, what has happened, many of the NBFC and financial institutions have already given project finance prior to 1st May. They have their obligation entered with the promoter. There is an escrow account wherein every month on the 1st or 2nd, the EMI gets debited. Now, Act requires that whatever money of the customer comes should be deposited in 70-30 ratio in separate account and normal account. So, whether that 30% would suffice to debit that recovery of financial institution, that is the biggest question mark. So many financial institutions are now rethinking or redesigning their proposal. They say, okay, now we will give you moratorium period. Instead of getting the principal, you just serve the interest. That talks are going on. So if that thing happens, then the promoter will not be in a problem. Otherwise, there is certainly a problem with the promoter, because he will have to serve that principal plus interest, plus he has to carry on the project also. So
secondly, already a construction finance is already done. The disbursement now, further disbursement. Suppose I have 100 crore funding, out of which I have utilized 50. My next stage is at another 10. So the 10 which comes in will automatically go to the designated account.
It will go to your normal account. Okay. See, designated account only customer fund. Okay. 70% again.
Ajay bhai, only allottees money is going to go in 70% account.
But the
loans,
very first
other
question
anything.
is whether now that bank will rethink on giving you the further disbursal based on these issues. So what is the feeling is, initially whenever the project finance is given, the EMI was such a big amount that initially the project funds were used to serve that EMI rather than giving the payment to contractor. So now they will think of moratorium, whereby they only want to recover the interest, and they will recover the principal later on.
So in short, there would be some restructuring.
Yes, there will be some redesigning will happen.
But the issue may occur that existing loans you may face difficulty, because any such change in the terms of those loans, existing loans, bank need to move a higher provisioning. So existing loans is going to be a huge challenge to get this postponement of payment of repayment of principal amount.
Then RBI will have to play some crucial role.
But this need to be brought to the notice of the RBI what the issues,
Yeah.
and that can be done by industry,
So that's
not
what
by anyone else.
Builder Association should represent to RBI also, direct the all bank for further redesigning, because what has happened, State Bank has issued one circular saying that after 1st August, if the project is unregistered with RERA, now again we have to prove them that our project was not required to be registered. But suppose by any default project remains to be registered, then they will not get any project finance or balance disbursal. Again, the customer of that project also will not get housing finance. So once the State Bank has issued this circular, many other banks will follow. So again, this is going to cause a problem.
Yeah, Ashwinji, I just want to check up with the company side. I have a project where 100 flats are constructed. I've got a OC, but as per the law is concerned, I'm not required to register. But I want to market it. So none of the registered broker can market my project because I'm not registered. And if they market, 1,20,000 has already been levied penalty to one broker, then they will start. The banker will not give the loan. Okay. And the customers are so alert now. आपका रेरा registered है क्या? Sir नहीं है. तो मुझे flat नहीं चाहिए.
Correct.
मतलब even the customers are saying, are you registered with RERA? No, I am not required to register. मुझे वो समझ में नहीं आता है. RERA number है क्या? नहीं है. So given the circumstances, Ketanji and Kapatis, if I want to do the voluntary registration, where I have completed the OC and all, and still can I do the registration?
Certainly.
I understand the concern. But strictly speaking, there is no provision in the law that we are regulating only those projects which are under construction. सब दुनिया का ठेका हमने नहीं लिया, ऐसा हम कहें।
नहीं, ठीक, सर।
जहाँ पर completion certificate हो गया है, सब building तैयार हो गई है, the purchaser can go and see, inspect, उसमें क्या बना है, कैसे बना है, तो he will be aware of all those things which he is expected to know, and therefore he can verify the things, and if his wisdom dictates, then he would purchase, otherwise won't.
Sir, adding to this one small point.
So far as the registration is concerned, let me tell you that the registration expires on the day when the time stipulated is over.
Sir, I am registering.
Or the project is complete.
Okay.
Therefore, our regulation, हमने जिंदगी भर नहीं उसे निभाना है. जब तक वो तैयार हो जाती है, completion certificate आ जाता है, conveyance हो जाता है, खत्म. फिर उसके बाद 5 सालों तक अगर कोई डिफेक्ट रह गया है, वो बिल्डर नहीं करता है, तो हमारी तरफ आइएगा.
Okay, I just want to ask you, I want to register for 0 day. I have got a completion about 2 years back. I want to register for 0 day. Can the 0 day be not considered as the period of registration? 1 day is a date of registration. So 0 day is my period of, the day I register,
Sir,
the day I...
हम पैसा कमाने के लिए वहाँ बैठे नहीं है. We are getting registration fee.
Now again, what do you mean by completion of
लेकिन जो practical है, what he is telling is right. Because ultimately when the people are talking about the registration, MAHARASTRA and all these things and the practical difficulties in taking the loans, so normally the person feels that it is better to take the apartment from the project which is registered.
Sir, section 3 very clearly बोल रहा है, no sale, market, advertisement can be done unless until it is registered.
No, but
and it says provided further.
But you are excluded.
No, provided further it says only ongoing project should be registered within 3 months. But there is nothing which prevents or which does not say that law says even after the completion of the project that requires registration if you are doing a marketing.
Mr. Prabhu,
this is section 3.
Mr. Prabhu, I am representing authority here.
Yes, sir.
So far as the view of the authority is concerned, it says that there is no point in registering such a project because it is already completed. On the completion certificate, the registration expires. So when the project is complete, occupation certificate is there, then there is no point in registering it.
No, but sir, what do you mean by project completion? Whether it is just the date of receipt of OC or there are some more obligation also like society formation, conveyancing. So whether your date of completion of project is what? After conveyancing or only receipt of OC?
Receipt of OC.
I think there are some
to add to Mr. Prabhu, there is always an end date to a project. If you have received the OC, the end date would be backdated, which you will not be allowed to. So this is in terms of when you register this project. You would not be allowed to register because
Okay.
it's an
I request you to go through one project which is registered by MAHARA.
Hmm.
They said we will complete, original date of completion was 2016, and they said the end date of completion of the project is also 2016, and that project has been registered. In form number B, affidavit, they said we'll complete the project in 2017. So your website, to that extent, is a faulty. That is what I want to bring it to your notice. If the project is of 2016, where they have said my end date is also 2016, the project has been registered, you can go through.
Point taken and we'll get it checked.
That's correct.
Now again, what Prabhu is saying, when the project is exempted, because OC has received prior to 1st May or say prior to 31st July. So can RERA give one certificate that these are the exempted projects?
Absolutely.
Because that we can show to the banker, and then banker will give housing loan to that customer. Otherwise, right now, the banker will straight away say, if your project is not registered, we are not going to give housing loan to that customer. Because there will be second, third sale also later on.
What is the end purpose of the law? It is to have a transparency. And the project which is completed OC, you don't want them to be loaded on the website in spite of agreeing and voluntarily coming forward. I think that is not acceptable. Voluntary income tax return, even if I am not required to file, I am filing. That is accepted. Everywhere it is accepted. Even GST voluntary registration is expected or allowed. So I think you should be allowing us. That is my request. And representation here.
Okay, now coming to...
That's sir.
Now coming to promoter, you are again, there is a delay of project because of approval system. In India, we have seen what you have expected, I will get all the approval in say 6 months or 10 months, but it goes on, and it sometimes takes 3 years, 4 years. So then your all project timeline, what you have estimated goes beyond, your interest cost also goes beyond, and your project which was profitable becomes loss-making project. So what you want to say on that?
We definitely, this has been oft-repeated point to all the authorities. Our all representation to CM sir or any higher authority whom we are representing, we are always asking for one window clearance system where all permissions, if it is given in under one window, it would, it would be as like if a consumer comes to RERA, he is sorted out. A developer, if he comes to RERA, let him be sorted out. We would be happy to, what you give, we promise. That's the end of it. I mean, we would like to put it in that way. But still, there are so many permissions that we need to get. Our request time and again has been that if it is sorted out, to a great extent, this government is trying to sort out, trying for ease of doing business, but actually it is still not percolated down to the level. To be honest, right now you are observing, when you say started your thing, only 200 projects have been registered. There is a wide range of reasons why only 200 has been registered. Since I am heading the developers community here, we often have discussions amongst all of us. Everybody is not that they want to shy away or go away, but there are so many things which are pending. Everybody is today running to the lawyers, the chartered accountants, their architects, and for municipal authorities and their finance authorities, finance like banks and everybody, trying to coordinate with everybody. The entire staff is working overtime in our offices just to comply because we don't want to put anything wrong and then again have the stick, So the whole issue is all these approvals. Even the permissions are taking its own time. There are a lot of projects which are just about to get OC, but we are stuck for whatever reason. So that is why
I just want to add only one point. Here, approval, even if it is delayed and all, unless until the project is approved, you cannot register. So therefore, I don't think there is an issue.
For example,
approval also. You can have approval for part of the project. Later on, you can have proposed
in
approval.
that case,
and
there
apart
is
from that, there are some environment clearance which you need to get later on. Firefighting and all this.
In that case, Regulation 26 of 24th April 2017 contemplates very clearly, If the project is getting delayed because the permissions are not given by a competent authority for certain approval, you can approach the competent authority who will summon them, call them and ask them and give the direction.
But
So
sir-
article, section 26, that is a regulation 26 of MAHARASTRA regulation 2017.
Honestly, sir, we developer fraternity are really frightened to go against the. It is. I'm being very honest here on this forum कि वो नहीं होता है. कुछ भी चले नहीं होता है. And 2 lines are written which will delay. 2 चीज मांग लिया और our process is the project goes on getting delayed. This is what we all have, gone through.
Yeah, sir. First they write not approved NOT and then they write NOTE later on, right? So World Bank has made one study of 190 countries about the efficient approval system for construction industry. And the figures are very, very surprising. India rank is 185. Shekhar, it is not the marks. It is the rank. We rank 185 out of 190 countries. So this is the helm of affairs we are facing, and under this situation, we are asking builder to complete the project in time. When this, what Ajay said is very true, when they approach the competent authority, there is just one-liner answer.
Plus, there are new rules which are coming on constantly. Like, we are talking this, we are going and taking approvals. The common DCR for MMR region is the suggestion objection is going on.
Correct.
It will become a law shortly. 2034 DCR is going to come. So these are going to make changes. So what do you do?
Even in Thane, Godbandar area, many builders have submitted the application for completion certificate. Now, because the water department is told to submit one affidavit, there is a provision of water till 2025, High Court has given a stay for issuance of OC. Now, already based on CC, commencement certificate, many customers have already infused their money. Now, builders are facing the problem of giving the possession.
I am one of them.
Yeah. Now, there are many. And suppose that court order does not come prior to 31st July, then whether RERA will give extension to those OC which are later received later on. Because this is because of High Court stay order. So here promoter is totally
we have applied for
helpless.
OC. We have applied for OC.
There is provision in the law that the authority can extend the period of to the extent of 1 year, that too for the reasons to be recorded, mitigating circumstances will have to be.
Sir, I am talking of application before 31st July.
No, that period is not going to be.
Because they are not getting the OC, otherwise they would have got. Because of High Court order, they are not getting. Because the municipal officers are saying the OC is sanctioned, but we cannot issue it because there is a High Court stay. So this is the scenario in
Everything
Thane.
is done. Only issuance is pending.
Yes, yes.
Money is paid.
Money, everything is paid. It is a sanctioned one, but not issued.
But strictly speaking, once the OC is not there, then it will have to be registered.
Now coming to Harshad.
But I hope that as soon as we get the OC, we will be out of it.
No, but if you get OC on say 15th August or 16th August, then the deadline you will have to.
No, we will file it and we'll take a discharge.
Correct. Now coming to
There's
Harshad.
no other way.
Now this definition of carpet area, really is it going to help the customer?
Definitely.
My learned friend wants to answer
Achha,
that.
okay, Shailesh, you can answer, and then Arshad.
Definitely. Previously, we had a super built-up area, and that also very much ambiguity was there. Somewhere quoting 50%, 70%, 60%, anything, whatever builder can understand, that can be made understood to the buyer.
But Shailesh,
Now,
right now, under that there is no prohibition. Okay, you cannot charge more than other than carpet area. There is no such section or prohibition under the act or rules. It is just a definition is given of carpet area. Again, when we have an approval plan from competent authority, it has some carpet area. They include the wall also, internal wall. They exclude the external wall. So
But
there
now-
is a difference. So which is the authentic figure? The plan given by the authority or carpet area given by the builder? What is more reliable? That authenticated copy of the plan or
Now, I think the carpet area has been made mandatory under some law that it should be, carpet area should be mentioned in the sale agreement. So now that carpet area should be more reliable.
No, but who is going to certify that
What,
carpet area?
what he says is that which carpet area to be put?
No,
One
not-
that
not
is
even
defined
this.
by RERA, or what corporation gives, or what stamp authority, when charging the stamp duty, collects. It has a different way of calculation. Everybody, there is a different spectrum always. Which area to be put? I send my agreement for registration and try to say that this is enclosed balcony, which is, they said, no, no, don't put all this. Only one figure we'll take, nothing else. I mean, I'm talking of the stamp duty. So all these discrepancies, maybe these are teething problems which we need to sort out.
Government will have to come out with
What we feel is if RERA is the apex body, which we have to follow, let them stipulate and let them direct the corporation, this is how you will sanction. This is how plans will be approved. We are happy.
My suggestion
Since
is
common DCR is coming out, 2034 is coming out, you can write to them, okay, bhai, this is how you calculate, this is how you sanction, this is how it will happen. We are happy to
so
do
that synchronization has to be done between approved plan and the carpet area as per RERA. Because what will
Yes,
happen?
I think government will have to come out with some clarification on this issue. Because otherwise, what will happen then? Unnecessary litigations will prolong
No, but I
whatever
think
the
the
project.
carpet area which is to be mentioned in the agreement is as per RERA. It is not what is sanctioned or what is built up.
That is true. But again, the authenticated figure is given by the approval authority. Carpet area given by the promoter.
So we are left at the mercy of the promoter.
May or may not be
But
reliable.
that is, see, whatever has been
Now,
approved by the approving authority, that is the carpet area which should be mentioned by the builder.
There is a difference. As regard internal wall, approval authority include that wall while calculating, excludes, and promoter will include that, they ignore that internal wall and calculate the carpet area.
Promoter cannot make his own calculation and put up in
But
that.
RERA has told that. RERA has given the definition of carpet area which says that you have to ignore the internal wall, whereas this competent authority, they do not ignore, they
And then very
No,
much
Ashwin, there is some
clarification
confusion.
will be required.
There is some confusion. RERA doesn't say exclude internal walls.
RERA say you have to ignore the internal wall while calculating carpet area, whereas competent authority do not ignore.
Yes,
They exclude that area covered by that internal wall. So there will be difference in carpet area between approved plan and RERA
So
authority.
government
what will happen?
clarification will be required.
No, what will happen? Suppose I book a flat with Ajay. He tells me that there is a 1000 carpet area as per RERA. Again, when I go for possession, he will tell that it is 1000 carpet area. So how I will satisfy myself? Because there are approved plan while getting the plan approval, there are OC plan also. One has to
Earlier
submit.
what we used to do was, where you can lay the carpet was the carpet area. In general terms, in layman's language, where you can lay the carpet. Now, even that is not there. So for us to make our customer understand, it's not going to be easy. Because they don't know how to calculate other things. So that becomes a little bit of, so if we have one yardstick which is common for everybody, it becomes easier for everybody. That's the only humble request.
Now my one question to chairman of the branch, whether CA is allowed to certify the estimation, because Form 3 requires that.
As per the code of conduct applicable for practicing chartered accountants, a practicing chartered accountant is not supposed to sign any projected statement or estimated cost. So in fact, if you recollect in your very first lecture in association, most of the chartered accountants had raised this query. Now, I wish to ask the authority that if that is the case, because our regulating authority does not permit a chartered accountant to sign any estimated figure. So, what we are taking a stand that we will mention in the certificate that we are relying on the figures given by the architects and engineers. So, we cannot certify figure something to be reckoned in the future. We certify whatever has happened or what is actually happening. So is it acceptable to the RERA authority that we give a disclaimer that we are, whilst issuing this certificate of estimated cost of the project, because that is going to determine the amount of withdrawal from the bank, that we shall give a disclaimer that, yes, while certifying this figure, we are relying on the figures given by architect and engineer.
बेसिक थिंग आहे. अथॉरिटीमध्ये 3 लोक बसलेले आहेत. ॲडव्होकेट टायटल सर्टिफिकेट देणार, साईट इंजिनियर त्यांचं सर्टिफिकेट देणार, आर्किटेक्ट त्यांचं सर्टिफिकेट देणार आणि CA त्यांचे सर्टिफिकेट देणार. मग ही लोक कोण आहेत? These are the men of profession. They have added responsibility on their shoulders. So we say that these are the extended hands of the authority. We cannot put control on each and everything, but we are going to rely on the men of profession. If a responsible person, CA, there is a difference between business and profession. So these persons are professing their profession. It is therefore, these are the men of profession. They have added responsibility. They have been governed by their act, and disciplinary authority is there. If they are going wrong, they would be punished. So therefore we say that these are the responsible persons, and therefore we will rely upon their certification. So the authority is not going to verify as to what is certified, but we are going to believe the persons who have issued the certificate. Therefore my request is that this particular role to be played and the logic behind it must be understood. And then if this is taken, if it is taken into consideration, then naturally the responsibility goes to the CA. Now it is for the CA and their association as to how the things should be sorted out. Which type of instructions should be withdrawn, which type of instructions should be issued, it is between them. But so far as the authority is concerned, I am cocksure of the fact that these are our extended hands, these are the men of profession, and on their certificate we are going to rely. It means that they have also to satisfy the facts which they have been certifying.
Okay, see, when there is a law which provides for certain duties to be done by a practicing chartered accountant, naturally the law will prevail. This is one view. Secondly, we are not certifying the estimate. Let me tell you, what we are certifying is the balance cost to be incurred. Now, when I say balance cost to be incurred, first an engineer certifies what is the total cost of the project. Engineer certifies the total cost of the project is 100 crore. Then the chartered accountant has to verify how much has been incurred in the books of account. Let us say in the books of account, incurred can be verified. We have verified, incurred is 40 crore. Out of 100 crore, 40 is incurred. So therefore, balance work to be carried out is 60 crore. How I am getting? Because estimated by an engineer is 100 crore. I have verified the books that there is 40 crore incurred. So I am saying as per the books of account, only 40 crore is incurred. Therefore, the balance estimated cost as to be incurred as certified by the engineer is 60 crore. It is only a mathematical calculation which I am certifying.
Engineer role is only limited to the construction cost. What about interest cost?
No.
What about approval cost? What about future additional FSI, fungible FSI?
Apportionment of indirect
in
cost.
that case, we have to
All
believe.
these estimate.
Then we have to believe on the representation made by the promoter. The representation made by the
We have
promoter.
to put some
Sir,
disclaimer.
I think you are addressing the direct cost. But I believe that there are different 2-3 projects. So there is an apportionment of indirect cost project wise. That has to be there.
Yeah. Like selling an admin on.
I can
I'll
only
add to
tell you
Sukap.
that guidelines shows it's in making. I am part of that group.
Cash flow.
I can only tell you right now that the Institute of Chartered Accountant of India has already constituted guidance note committee in which I am already there. And let me tell you about 3 days back, we were there for 3 hours with MAHARASHTRA chairman, Gautam Chatterjee, where Aarti was also there. And we have discussed in detail as to what are the issues coming up. A draft guidance note has already been submitted to the authority, including Kapni Sahib. We met him for half an hour, we discussed, and we have also given a draft guidance note which may be issued by the institute in due course. So just preliminarily we have given to the authority for their view. Maybe in a day or two they will come out with their clarification. Thereafter the institute also will come out maybe in another 15 days. So that's the only thing I can tell you right now.
The institute, what issue is there, I'll just clarify on the first point. What the institute says, the text of the code of conduct, which bar said, permits the name or the name of the firm to be used in connection with an estimate of a earning contingent upon the future transaction in a manner which may lead to believe that he vouches for the accuracy of the forecast.
So in my interest
No, I'll just finish up.
I need to factor the future inflow also from customer. Then and then only I will be able to find out the interest.
I say, so I am not vouching the forecast, which is what is given by the builder, which is what is given by the things.
All that disclaimer should come.
This will, and even though if you say certificate says that the certificate has been issued for a RERA compliance for the company and is based on the records, documents produced before me and explanations provided to me by the management of the company. So it's already certificate is factored in this point. And again, if you see when the company goes for listing, there also where the forecast is done. Institute already given the guidance on that also. When the forecast is done, member of institute can be a part of that forecast.
So we have to wait for institute guidance, or we have
in
to
my
put
view,
disclaimer.
In my view, institute doesn't bars at the moment if I am giving the specific disclaimer that I am not vouching on the forecast.
Okay.
I agree with you because the law will prevail. Law demands that we should do, therefore we
and
can
again,
do
the institute original guidance which was issued in 1982 has been withdrawn in 2007. You need to understand that. What has changed in 2007?
Now coming to Arshad, now there is one provision in RERA Act which says that you cannot take more than 10% without executing and registering the agreement from the customer. Now, for ongoing project, promoter has already taken say more than 10% prior to 1st May. Now, they will not be able to take single naya paisa after 1st May.
Right.
But what would be the time? Because this is a transitional issue. So what would be the time where he should go and execute the agreement?
No, what is expected is that now that you have taken the money, immediately write a letter to that gentleman that you have paid me more than 10%, please come and execute the agreement.
Yes.
This is the agreement which I am sending you.
But then sometime customer may or may not cooperate. There are some investor because earlier, this provision was there on MOFA also, 20%.
Correct.
See,
I will rather tell practical situation which Ajay Bhai would immediately say that 50% of investors are out of India who cannot come within 15 days to execute a document.
Correct.
But they have paid more than 10%.
10%.
So as far as the role which is attributed to the promoter is concerned, he has to inform him, get the document ready and tell him that come for execution and don't accept further money till that document
is prohibited.
Otherwise, don't say that he is sitting abroad. What can I do? And then keep on accepting.
That is certainly prohibited.
So correct. So what is expected, Ajay Bhai, is write a letter to him, call him to India.
That too you would certainly do, but I want to highlight one small point here, which we have been undergoing, which authorities may not be knowing. It is, the rule has come now that at 50% when we do sale, even if it is not completed sale or it is not full payment or there is no, it is on booking. It is not on agreement also, or it is not on, what do you say, 50% of payment or 75%. It is only on booking. If 50% have booked, we have to make a society, which again, there are so many players in the market who are prone to this, who have gone to consumer court after booking something, paying a token amount, and then litigating, and then extracting money, and giving society into their hands. Suppose it comes in, take an example of a small building which has 28 flats. What would happen of that? It is easy for somebody to do certain things and then blackmail. It's a scary situation for us as far as this is concerned.
So what you want to say is, there is a difference between booking and selling. Booking can be by giving check of say 11,000 or 51,000. But selling requires execution of agreement, registration and all these things. So currently Act and rules say about the booking. So once I give 11,000 check, then I go and tell everybody I have booked the flat in Ajay Asar project. That this is what the common phenomena is there. So once I become the member of that society and then I cancel it, Again, there are procedure for expulsion or removal of that member. So this is all will be pain taking. So there we need the clarity.
We can have something 50% of the payment is made or something.
Why the society is to be formed? Society is to be formed just to keep watch on the activities of the promoter. He must act as per the terms and conditions agreed upon. इसीलिए सोसाइटी बनी है. अब ये सोसाइटी के मेजॉरिटी कैसे हम सोचेंगे? सपोज one person purchases more flats, 5-6 flats, in the names of his family members. Even then that would be treated as one purchaser. One purchaser. Therefore, it is very difficult to believe that some persons who have vested interests, they would come together and would harass the promoter. Possibility is there, no doubt, but we cannot generalize this.
No, MAHARASTRA in the FAQ.
One minute.
Yeah.
We are not saying that we don't want to form the society. We are saying that this booking amount should be replaced by selling amount, like registered agreement. So then there is an enforceable.
And he should not be a defaulter. And he should not be a defaulter in payment.
Yeah.
He should not be, that's it. Something makes sense where they are in their place, that's it.
Yeah.
They are genuine, we have no problem. The genuineness of the customer is what we are trying to address.
If they are making defaults, you can come, you can recover the interest if they are making default. But so far as the check and counter checks are concerned, it is the society which would be watching the activities of the promoter, and that is the logic behind it, that the society should be formed so that they would be able to control the activities if they are going wrong.
Sir, recently there was one order or circular from your authority stating that in case of public body which are required to submit Form 3 for the purpose of registration, so their chartered accountant has to sign that Form 3, right? So the order says that the head of the finance department of that public body would be deemed to be CA for the purpose of signing that Form 3. So again, there is a controversy role between chartered accountant and deemed to be chartered accountant. So, Shekhar, you want to say something on this?
I'll just say, see, the RERA authority has no such jurisdiction. That order is wide ab initio. Now only we'll have to go to the court or set aside, and the institute has already represented on this account and to the Ministry of Housing as well as to the all the concerned, including MAHARASTRA. And I think MAHARASTRA in due course will withdraw, because the act is very clear. MAHARASTRA Real Estate Regulation and Development Act 2016 has defined who is a chartered accountant. And there is a separate act of parliament, 1949, where we are today celebrating CA Day of 68 years. And therefore, a RERA authority, MAHARASTRA authority cannot come out with this type of order. And the act is very clear, a practicing chartered accountant. Can the head of the department, whether he is a chartered accountant or not, we don't know, first of all. And even if he is a chartered accountant who is in employment, cannot certify, it is to be a professional. So therefore, this order of MAHARASTRA is completely contrary to the MAHARASTRA's Act. It is, RERA Act 2016, Central Act. It is also contrary to its own rules. It is also contrary to the Act of Parliament. And therefore, the institute has already represented. And I think in a day or two, or maybe a few days, the same order will be withdrawn, and I will request Kapani Sahab and Ketan to inform the MAHARASTRA authority about this order, which is not in the spirit of the act.
Yeah, further, when any person is signing a chartered accountant, the basic objective of the CA Act is always that the person has to be independent. When that person is the employee of that company, he is never independent, and he has never given the authority to sign certain documents. And MAHARASTRA is the executive authority, and certainly it cannot override the law of parliament. That's already what you said. But they cannot, because CA itself is coming under the Act of Parliament. It is not association as such. It's coming under Act of Parliament. So whenever even if we want to change the syllabus, we need to go to the Parliament and get the things done. So that this executive order cannot survive on any basis. It may be wrongly interpreted sometime, but it cannot survive. It's a baseless.
I think authority has all the right to exclude this public body from this procedure, that they can do.
Even they cannot do that. Because when you look at the declaration which is filed at the time of registration by a promoter, that I will get it audited from a chartered accountant. At the time of withdrawing the money, I will get the certificate from a practicing chartered accountant. How can authority exclude them? No. There has to be saying that they need to make a panel of chartered accountant who will be independent practitioner, and they have to take the certificate. That's it. They are not above the law. The MAHARA or any authority whom they are talking about, government authorities, are not above the law. So I think this order itself is a wide avenue issue. There is a representation which is already done by the institute. I had about a lot of discussion with our president as well as the other concerned people. I have already made a representative to the institute. Institute has already made to the authority concerned. So I think in a day or two it may be withdrawn. And I would request in all fairness that order should be withdrawn.
I agree with this proposition that law is law, thereafter the rules and thereafter regulations. If there are some mistakes committed, then they can be rectified. If you have submitted your representation, it would come before us and would take the appropriate decision.
That's correct. Thank you.
Now coming to Paras, Form 3 is should be in accordance with rules and act. Now act says for the purpose of withdrawal, cost incurred means total estimated cost for developing the project. That is what act says. Rule says cost incurred. Now when we come to Form 3, there we have land cost, construction cost, approval cost and interest cost, right? Again, the selling and administrative costs are missing right now in Form 3. But they are also part of the project cost, because without having a proper legal team or admin team or selling team, one cannot develop the project. One cannot realize the money from the customer if I don't have a very good selling team. So these are the part of my cost incurred. But currently Form 3 does not allow these two items, selling and admin cost. And again, these costs are in some case more than 10% of the project cost. So this is going to be creating a problem.
Certainly, at the rules at one stage, except this, there can be a selling cost. The rules are specifically said. They are not brought in the Form 3. That's the error what is there.
No, rule says offsite and onsite,
Yes,
both.
no, they accepted the cost.
Yeah.
There can be cost, admin cost, that's what I accepted it. So rule 3 is, Form 3 which is not providing at some place, I don't think so, by it's a lacuna or what's a mistake is there. And if even though that you need to put on by way of note that this includes the so and so cost as covered by the so and so rule.
No, I think there is a order recently passed by the authority which says that these marketing cost and all this cost is not included in the project cost. That is to be borne from subject to correction from.
Ketan, you want to say something? On this?
I'll just add, on 28th of June, that is just about 3-4 days back, the MAHARASTRA has come out with a clarification. There is a cost of the project and the cost of the project for MAHARASTRA. So the cost of the project includes selling, marketing, everything. As far as the cost of construction and land is concerned, that is what is the cost of the project contemplated in the Act. So therefore, marketing and selling expenses need to be excluded. That cannot be part of the project cost as far as MAHARASTRA is concerned. MAHARASTRA, if you look at the definition of the cost of the project, it says land cost and construction cost. There was a debate, as I said, when we were discussing about the guidance note. On 27th June, we had been there. So the next day, when we raised this issue, we said, sir, the cost of marketing is a cost of the project. MAHARASTRA authority agreed. Yes, I agree. Cost of the marketing and the brokerage, everything is a cost of the project. But we are governed by MAHARASTRA Act. MAHARASTRA means the Act, RERA Act. The RERA is very clearly says land cost and construction cost. And that is where the withdrawal of 70% comes.
No.
You have a marketing expense, take out from the 30%.
No, but when you go to definition which is given by Act, it very clearly says estimated cost of project means. When they say means it is a comprehensive definition.
That's correct.
It says means total cost involved in developing the project.
That's correct.
These are the words.
What is the meaning of
But
development?
for what it says, if you see the definition, means the total cost
involved in developing.
How can there be development without selling?
Project.
And further it says and
Selling is a part of development. Let us not exclude it from
That
it.
is inclusive.
No, that's what they say, and includes the cost.
So, to my opinion,
So that doesn't exclude at any point of
let
time.
us compare two projects, one having a very good legal team, admin team and selling team, one does not have. Which project will get developed? Very, very logical. So the Act will prevail Act says the cost of developing the project. And in developing the project, sales plays very crucial role because there are sole selling commission ranging from 5 to 10% also. Legal experts are there, admin cost is there. So all that should form part.
I agree with you, but if you see the form which we are
form
supposed to,
cannot
yes,
override the act.
correct, but it only provides for space for on-site expenses. There is no space for off-site expenses.
Since we are getting it to the
authority,
authority,
so it is, we are
will
just trying
request,
to,
it will help the project in the long run.
Clarity from
It is just if we want to work. There should not
three-
be impediment to work. That is the idea. And this money is going for, now we put one ad in the paper, we know it costs lakhs of rupees. So after all, it has to be reimbursed from the project cost. And then the project will go faster. The more sales we get, you will have more in your, both the accounts. We'll be happy.
Out of this 70%, promoter is not allowed to withdraw the profit. Suppose in that 70%, 10% is profit. That is not allowed to be withdrawn, only cost incurred. But at least selling and admin, which forms the part of cost, should be allowed to be withdrawn because a promoter is required to pay even sole selling agent on a regular basis.
no, and to add to it, sir, what will happen here is, on one hand, we are defining project cost. On other hand, you are saying, out of this 30%, use the money for advertising. But that 30% has to be there part of that 100%. If you are saying reduce that advertisement cost, reduce other costs, it is never going to be part of that 100%.
Correct.
So it will never tally, sir. That will be a practical difficulty
No, there will
which
be
I foresee.
delay in withdrawal.
Yes.
When I get my OC, I will be able to withdraw that amount later on, when I get my OC. So there, that clarity, sir, we require from authority. Again, for landowner issue, now in case of area sharing, suppose landowner is getting say 50,000 square feet and he has sold on the very first day. Now he is getting some say 50 crore, but his land cost is only 10 crore. Now again RERA says you will be allowed to be withdrawn up to land cost only, cost incurred. So 40 crore will remain in the bank account of landowner till the OC is received. So that is the reason now landowner are saying we don't want to give our development agreement, we want to better sell the land and get rid of all these things. Right, Ajay?
Yeah, and banks are not giving money for land. So where will the money come from? We are not allowed to withdraw from the designated account towards the land. So where will the money come from?
SBI has come out with the land, for the purpose of lending. For the purpose of buying a land, they are ready to give up to 60% of the land cost as the funding at 10.95%.
So slowly and gradually this will come.
So the SBI also come out with the builder funding for two types. One is a construction finance where you get 80% of the deficit funding required. When I say deficit funding for the purpose of construction, that means whatever is the sale proceeds you are issued and what is the construction you have estimated, that is called deficit funding. On that 80% you will get at 10.95. So I would say a days to come, you will have all good money coming here. Instead of coming, black money, which is getting circulated in the real estate projects, now you will have all bank funding coming. The SBI has already taken a lead, others will follow.
Yeah, that is what we are expecting.
And that too at 10.95%, which is very good.
So the revenue of government will also increase.
That's
with reduction in black money. All direct.
And
indirect
having given an
stamp
industry
duty.
status, having a regulation, infrastructure status is given, you will have a very
That
good
is what
days
I
to
started
come.
with.
You
That
will
is
have a
what
good
I
days.
started with.
So now with this we conclude the panel discussion. Just
And before, I just want to say that really I wish to each one of you happy CA Day, happy GST Day, and happy Doctors Day, and happy International Cooperative Day also. The first Saturday of every year is always celebrated as an International Cooperative Day, and today is the 95th International Cooperative Year. And let me tell you, the theme is nobody should be left alone. That means inclusive. So therefore, GST is also talking about inclusive, one nation, one tax, and RERA is also talking about including everybody, all the stakeholders, including professionals and chartered accountants. I think these days and the day is going to be very, very historic day. And historic day because Ketan, who is a chartered accountant, is a consultant to MAHARASTRA and the authority himself, adjudicating officer who has been recently appointed as adjudicating officer, retired district judge is with us. And I think a lot of questions we have posed and a lot of clarity has come. I congratulate the chairman of this branch, Shekhar Kulkarni, and I would like to present the book which is also available at a discounted price at the counter to the branch, which I have written on the Act, rules, as well as on MAHARASTRA, which has got the forward message from MAHARASTRA Chairman Gautam Chatterjee, as well as Housing Minister Prakash Mehta. Thank you very much. It is available at the discounted rate. Thank you.
Now we are on the verge of celebrating 70th Independence Day on. Achha, you want to say something?
Last question. Sir, interest payment provisions is there for any lapse by the builder. You levy penalty also. After all this, builder, in the scenario of the increasing prices, builder can afford to make payment for interest, penalty, everything. But prolong the build cost project. What about my home? What about my flat? How I will get my flat?
This is the last question to be answered. The penalty to the extent of 5% of the project, or sometimes 10% of the project, is too heavy penalty, and no promoter will be able to afford it. That's all.
Hope so.
Now to conclude, we are on the verge of celebrating 70th Independence Day on 15th August. And even after so many years, we are not able to give a law which is right from the day one, free from doubts and ambiguity. This is because lawmakers are not ready or not willing to take into confidence the professional bodies. Like in RERA, suppose we have the consultation of architect, engineer and chartered accountant. Things would have been much better. Prior to enactment, if all these things have been done, then thing would have been very easy for all of us. Now when we talk of Bollywood industry, Vidya Balan says entertainment, entertainment and entertainment. When we talk of real estate law, authority and state government requires from promoter disclosure, disclosure and disclosure. But we, the law-abiding citizen and peace-loving people of this country, would require from government and authority clarity, clarity, clarity. Thank you very much.